Hey, welcome to today's video. I'm Richard Chapo. I'm an attorney in San Diego, California, and I've been advising California businesses, particularly online businesses, for about the past 20 plus years. So today we are talking about CCPA, the definition of personal information. The CCPA is the California Consumer Privacy Act. Is a new privacy law that was enacted in the summer of 2018. Part of it goes into effect on January 1st, 2020, and the second aspect of the law goes into effect later that summer on a date yet to be determined. The Attorney General is working on regulations, and once those are done, that's when it all goes down. Anyways, the definition of personal information. So we're really looking at the crux of this law. If information that you collect as a business is included within this definition, then compliance is something you're going to need to look further into. If it is not included within the definition of personal information, lucky day. Where do we find the definition of personal information in the CCPA? That would be section 1798.140, subsection O. That's O, not zero. Subsection 1. And yes, that should probably already give you an idea how fun this is going to be. Now, the definition of personal information is exceedingly long. It includes a introductory statement and then a long list of categories. I can't publish them all here on the video because the print would be so small that you wouldn't be able to read it, and I'm too lazy to make a second screen. So instead, I've added them to the description of this video on YouTube. So if you're watching on YouTube, just scroll down and read the description. If you're not watching on YouTube, if you click the video, particularly in the lower right-hand corner, it should take you to YouTube and you can see the descriptions. So with that in mind, let's get to it. So the definition without categories, without mentioning the categories, well, we'll talk about them, but without listing them here, is right there in front of you. And you can see how broad it is. Keep in mind, this is very, very broad. They're throwing the net very, very wide. So let's just read it. Personal information means information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. Personal information includes, but is not limited to, the following, and these would be the categories. If it identifies, describes, relates to, is capable of being associated with, or could reasonably be linked with, directly or indirectly with a particular consumer or household. Now, if that sounds like a cluster, you know what? It is. So let's just look at some of the language. How about, or could reasonably be linked? What is reasonably be linked? What are these terms? They're very vague, very vague. And this paragraph may only be, 25 words long, something of that sort, is going to spawn decades. Well, maybe not decades, but let's going to say it's going to spawn years and years of litigation. Millions of dollars will be spent on this paragraph, arguing over, what is relates to, what could reasonably be linked with, what is capable of being associated with. What does that mean? I think Angelina Jolie is a beautiful woman. Does that mean I am capable of being associated with her? Probably not, but you can see kind of how this is going to go down. It's just going to be it's going to be a mess. But, nonetheless, that's the way they've gone. Why are they doing it? The reason is actually, it's not out there. There's a logical reason for doing this. And the problem that we saw in the late 1990s and the early 2000s was we had plenty of laws passed regarding the internet. But those laws used definitions that reflected the technology and strategies of the time. And of course, as you know, with the internet in particular, 3 years later, most of those definitions didn't really matter. They weren't applicable to the then current technology. Imagine trying to do a definition for personal information in 1998, and then later on, once Facebook, arrived, and once Facebook began collecting information in the unique way that that company does, and then parsing it out for monetization to advertisers, was something we hadn't really seen before. So the definition for personal information in 1998 didn't really cover most of what Facebook was doing, and made that law kind of useless. We saw the same thing in copyright and other areas as well. So now the new strategy is to create these definitions that are so broad and vague that the idea is that hopefully they'll catch not only what's going on now, but developments that will occur in the future. Whether that works or not is going to be litigated for a very long time. So what are these categories? Well, let's just read them. They're a mouthful, so I'll apologize ahead of time. But let's just start with the last paragraph then. Or the last sentence. So personal information includes, but is not limited to the following: if it identifies, describes, relates to, is capable of being associated with, or could reasonably be linked with, directly or indirectly, with a particular consumer or household. A, identifiers such as a real name, alias, postal address, unique personal identifier, online identifier, internet protocol address, yes, IP addresses, email address, account name, social security number, driver's license number, passport number, or other similar identifiers. B, any categories of personal information described in subdivision E of section 1798.80. This is another section of the Civil Code that also has an equally broad definition of personal information. Now, this is the point where I tell you, don't do this yourself. You need a lawyer, whether it's me, somebody else. Find a lawyer in California that can do all this for you, because this is going to be a technical one. C, characteristics of protected classifications under California or federal law. If you have those protected classifications, you probably already know what they are. D, commercial information, including records of personal property, products or services purchased, obtained, or considered, or other purchasing or consuming histories or tendencies. Now you might be thinking, products or services considered, what does that mean? Well, it does sound kind of laughable at first, but I think what they're looking at is a situation where a person starts to make a purchase and then changes their mind, and the company starts sending them, data or marketing materials based on that. E, biometric information. F, and here's where things get ugly for online businesses, internet or other electronic network activity information, including but not limited to browsing history, search history, or information regarding a consumer's interaction with an internet website, application, or advertisement. And then G, geolocation data. So most of that information is going to be collected by every single website or app. Your servers are going to collect it. If you use an analytics program, which you should be, that's going to collect that. There are many different ways that we collect information, and pretty much all of them are going to fall under those definitions. So bad news. G, geolocation data. H, audio, electronic, visual, thermal, olfactory, or similar information. Yes, because Big Data is going after the smell database. I, professional or employment-related information. Okay, that makes sense. And then J, personal favorite, education information, defined as information that is not publicly available, personally identifiable information as defined in the Family Education Rights and Privacy Act. Now, whoever drafted that language should be shot. That's just, man, could you make it any more confusing? But what they're really talking about is FERPA. FERPA is a federal education law, federal privacy law, applicable to education records. It was drafted and enacted in the 1970s. So as you can imagine, not exactly update with the current situation. Nonetheless, it deals with the records in schools. And so it's kind of an odd inclusion, but nonetheless, there it is. And then finally, K, and this is a nice little catch-all, inferences drawn from any of the information identified in this subdivision to create a profile about a consumer reflecting the consumer's preferences, characteristics, psychological trends, predispositions, behavior, attitudes, intelligence, abilities, and aptitudes. So basically creating consumer profiles. And there you have it. The bastion of fun. And so these categories, they're going to be investigated significantly in lawsuits. They just are. It's going to be a fascinating game to watch play out. And unfortunately, as a business, if you're trying to plan now for this law, there are a lot of ambiguities. So make sure you work with an attorney. What about enforcements? Is this one of those laws where everybody rolls their eyes and it's not enforced? No. So with the GDPR, the European privacy law, there have been a lot of questions about how exactly they're going to enforce it in the U.S. against U.S. companies, particularly smaller ones that have no ties to Europe. And that's a good question. We'll have to see how it plays out. With the CCPA, that question doesn't really apply. Because not only is this California, United States, but you have things called sister state judgments, which means states will usually honor judgments by other states. And then we also have the problem simply of the nature of this law. The CCPA is a self-funding piece of legislation. So when the Attorney General in California recovers damages and fines and what have you from a company, it keeps a percentage of that money to pursue other companies. So it's going to have probably a pretty nice, little cachet that it can tap to pursue investigations. So this one's going to be active. There are going to be a lot of investigations. There are going to be a lot of penalties, a lot of fines. And so you need to pay attention and you need to deal with this. Now, again, this is a legal topic that's going to be very complex. The CCPA is a bit of a mess. So you want to make sure that you are working with an attorney and that you have, justifiable understanding of what your personal information is, your duties, and to the extent you're going to avoid those duties, the legal basis for doing so. And you want to have that all mapped out before the Attorney General gives you a ring-a-ding. So anyways, that's it for today's video. We're creating a playlist on CCPA videos. If you go to our page on YouTube, you will see that playlist. And I don't know how many videos are in it now, but we're adding to it all the time. So if you would like to read or learn more, that's the place to do it. So anyways, thanks for watching. Have yourself a good one.